All right, everyone, we're live. Welcome back to the Judicial Proceedings voting session. We left off with the discussion for no knocks, and so based on the discussion, we have some actual language before us that we can consult. So I'll kick it over to counsel to give a brief descriptor of what we discussed, and we can move on from there.
So, sure, it's was just distributed. It's SB 419 378474/1. That's actually the same. I apologize. It's actually the same number that you had earlier, but on this version, you'll see track changes in the margins. So just going through the bill, or maybe it would just be easier to give some recap. So with the amendment, it includes a reporting requirement for each law enforcement agency. The reporting requirement can be found on page... It's the last 2 pages of the, or actually the last 3 pages of the reprint. It's in a new section 3524, and it defines no-knock warrants. This is modeled off of legislation a few years ago that related to SWAT reporting. The specific information that would be required to be reported, though, in this pertains more to the execution of warrants. So if you look under subsection B, there's a list of items that would be required to be reported by each law enforcement agency. That includes the number of times a no-knock warrant was executed by the law enforcement officers employed by the law enforcement agency in the previous 6 months, name, county, or county and municipal corporation, and the zip code of the location where the no-knock warrant was executed by officers employed by the law enforcement agency. For each search warrant executed, the number of days from the issuance until the execution of the warrant, disaggregated by whether the warrant was a no-knock warrant, the legal basis for each no-knock warrant issued to law enforcement officers employed by the law enforcement agency, and the number of instances in which a search warrant was executed under circumstances in which a law enforcement officer employed by the agency made forcible entry into the building, apartment, premises, or place specified in the warrant. So those would be the list of things that would need to be reported. And then this information, the bill would require that MPTSC, in consultation with what was formerly GOCAP, needs to develop a standardized form for reporting, and this would go to the agency that was formerly GOCAP. Then the amendment also provides, it might just be easier to go through the process. So if you go to page 2 of the reprint, in general, with this amendment, the application for the search warrant would, in addition to the affidavit, actually as part of the affidavit, would need to contain any information known to the affiant about the presence of minors and individuals with disability who may be encountered during the execution of the warrant.
Is there like, I don't know if this is semantics, but like not only disability but vulnerable adult, or is that a formal? I don't know if that's, it may be semantics, but I'm not.
Yeah, we could. I think there may be some language to that effect. I can search for it during the discussion.
Sure. Yeah. I think I want to make sure we just include it.
Presence of minors, individuals with disabilities, and vulnerable adults.
Yeah, that's right.
And as I'm looking at it, just above line 10, there's a typo I did want to highlight. That it said that an application for a search warrant may not contain a request that the search warrant, that's from the original bill. So no-knock warrants with this amendment would still be authorized, but there would still be the time of day restriction, so judge could only authorize the issuance of a warrant between hours either after 6 a.m. And before 10 p.m. Unless the judge found good cause for doing so. I'm sorry. Yes. Right. So not would be removed.
I'm sorry, why is it not stricken in this, or is it just a typo?
That was a
sorry.
typo. So part of the original bill,
I see.
right? So the court would be authorized. I'm looking at page 3 of the reprint. The court would be authorized to allow for the search warrant to be executed at the times that I mentioned earlier. But additionally, there's a part in Roman 5 that says, if determined by the issuing judge to be justified by information concerning the presence of minors and individuals with disabilities in the application, the judge may, or the warrant may restrict the time, place, and circumstances under which the warrant may be executed. So we could add, or vulnerable individuals. So additionally, if you go down to the new 3523, which is below line 9, it provides that the officer would need, before a search could be commenced with a search warrant, the state's attorney or the state's attorney's designee for the jurisdiction in which the search warrant is to be executed, and a member of the command staff for a law enforcement agency involved in the execution of the search warrant needs to have reviewed the search warrant and have been informed by a police officer who will be present at the execution of the warrant of the circumstances under which the warrant will be executed, and have approved the execution of the search warrant immediately.
Can I just, real quick, I just want to, I see Senator West has a question, but I also want to just ask Senator Jackson and Bailey, just, is that the right language, like command staff, command officer? Is that the right term? Can we get Jackson?
Yes.
I got it. Senator West.
We're going to take this language out about how people who are going to be present at the time of the execution of the search warrant have to be present in order to explain what's going on, in this case, to both the state's attorney and the member of the command staff. Didn't we say that we were going to replace that with the affiant? The person who made the affidavit has to be present in order to, and the reason is to answer questions about the application for the warrant. This was, I think Senator Bailey talked about the logistics of getting all these people marshaled at the same place.
That's right. That's right. So that'll be, we'll strike that.
But you can put the maker of the
affiant.
affidavit in their place.
You said with the affiant.
So, has been informed by the affiant for the search warrant of the circumstances under which the search warrant will be executed?
why he's there, just say he has to be, or she has to be present. Because whether you're before a judge or the state's attorney or the commander, when the search warrant is presented, there may be questions, and the best person to answer the questions is the person who made the affidavit.
Say that again.
The warrant's going to be executed?
No, I think our conclusion was we shouldn't try to micromanage how it's going to be executed. The questions are why you need a search warrant. What is the basis for the warrant? And that's what the affidavit is all about. Why do we need the search warrant? I'm not a criminal lawyer, but I'm almost positive I'm right on this. So that's why the maker of the affidavit appears before the judge. So, and frequently, it's like after hours, into the judge's house, and he's there in his bathrobe, and he needs to have somebody present who can answer his questions about why this warrant needs to be issued at this particular time.
Right, that there are questions about the whether or not there's or to determine whether there's probable cause to support
Precisely.
the issuance.
And those are the questions the maker of the affidavit can answer. He can't answer how it's going to be executed, how many people will be there, whether those people at the front door and the back door. He doesn't know that kind of stuff.
Sure.
He was the person who made the affidavit on the basis of which the warrant's being issued.
So the goal then is to, I guess just so I'm clear, is the goal to have the person in the command staff as well as the state's attorney or designee also sign off that there's probable cause for the...
That's the whole reason, to get them to review the warrant, right? That's why we want 3 levels, so we can make sure that the warrant really is necessary and that the no-knock element of the warrant really is necessary.
So that's a little bit different. So for the no-knock element, the issuance is predicated on the judge finding that there is reasonable suspicion to believe that evidence would be destroyed, or that it's a property subject to seizure may be destroyed, disposed of, or secreted, or the life and safety of the executing officer and other person may be endangered. So I guess is that what you're looking for the sign-off on?
I'm sorry, what are you reading from here?
That's not the initial. Senator's cabinet.
Honestly, I thought that we were looking at for the sign-off by the state attorney and the chief of police was that, I mean, the judge is the one who's determining whether there's it's appropriate to issue a search warrant, and what the state attorney and the local chief are signing off on is that they have knowledge of the criminal element in their community, and they also have responsibility for the public safety of their community, and they're making a value decision that the risk of executing a no-knock warrant is, in their opinion, worth that the public safety interests justify the risk that a no-knock warrant places under these circumstances. They're not second-guessing the judge as to whether the warrant should have been issued in the first place. It's more of the weighing that, yeah, okay, it's appropriate to have a warrant, but should we no-knock this, or is that risk really justified under these circumstances? And the state attorney and both the chief would have a knowledge of, the entire criminal element and how important this particular crime investigation, this particular crime is to the overall safety of their county. And so as long as they've conducted that weighing process and they're willing to say, yes, this is worth the risk, I think that's all we're really looking for from them. I have a question, maybe you covered this, I wasn't paying attention, but this section 523 on its face applies to all search warrants. Is that?
I was going to bring that up based on what you just mentioned, Senator. So as originally drafted, the amendment, and I hadn't changed it in the redraft, as originally drafted, it did apply to all warrants, and that was obviously because originally no-knocks were getting taken out. Mm-hmm. That would be something to change if the scope of this for the review
I
was
think the
limited.
discussion was not to have the
right.
state attorney and the chief sign off on every
Right.
search warrant. That would just be onerous. That the idea was to limit no-knocks, put them in a special category, and so, anyway.
Yeah, you can just refer back to 1203. A police officer who's executing a search warrant under criminal procedure 1-203 or 1-203.
Well, we've defined no-knock on 3524A4. We've defined the concept of no-knock
Right.
warrant.
So I guess it's a technical question, but it would either be to include the definition of no-knock warrant in 3523, or just spell it out like it is in the definition. Just
Remove
to
the
say
definitions
that
above
a warrant authorizing entry into the building, apartment, premises, place, thing to be searched without giving notice of the officer's authority or purpose.
I like the definition.
You can always just move the definitions ahead of
Sure.
in the order here, right?
Okay.
So define and then use.
I'm sorry.
Can I give a few more questions I have on this real quick? Yeah. And I guess Senator West sort of covered this, so I don't want to overstate a point, but it says, I think his point was the 3523A, Roman numeral 1, number 2, has been informed by a police officer who will be present for the execution of the search warrant. I think that, I mean, my understanding from discussing it with our law officer friends, I mean, I'm the cop who went and got it, and now I can't go for whatever reason. This team is executing it. And then has approved the execution immediately before the officer enters the building. We were putting a time frame on that, not immediately. I mean, number 3 right below that has approved the execution immediately before the officer enters the building. I thought we were giving him a little, we were talking 5 to 7 days, and this says immediately before. And then Roman numeral 2 says that the language about reasonable notice that a search warrant is being executed has been given to any individual inside the building. I think maybe Senator West discussed this piece. It's a no-knock warrant. If you're going to go around calling the building owner and everybody else, you just kind of jeopardize the lives of everybody executing a no-knock warrant. I mean, the whole idea there is that we don't tell people who aren't involved in the no-knock warrant because the risk of disclosure is death. So to be telling the building owner and other people in the building, you've just compromised your security about the no-knock warrant. And now
Yeah, so you could strike that, and then this piece we had this discussion about them on, I guess it's unnumbered, the numbered page, but it's the next page at the top, Roman 2. So this was the piece that we were talking about. You're like, well, you have to read them the warrant, or is this the made before immediately upon? So like you secure the scene. Is that language in here? Did that make it in here?
It did.
Okay.
So that is in C. So I think on the page
Got
that you were
it.
just looking
After
at-
making entry and securing, but before searching the building, apartment, or premises, place, or thing specified in the search warrant, an officer participating in the search warrant shall read and provide a copy of the search warrant.
Where are you looking now?
Subsection C.
E?
C,
Oh,
as in
C.
Charlie.
Okay. Yeah, I mean, so that whole piece, we're taking that out too? Is that what
So,
you're saying?
no, that's what we talked about, but I guess it wasn't qualified by the language there about after securing, after making entry, and securing the premises, but before searching. So you could secure everything, you're safe, all your colleagues are safe, then you tell them, hey, we're here to search this. I think that's what was missing during our last conversation. That language was not there. People were, because it was like presented that like, oh, you go in there and then you have to find the person and read them secure the place, tell them why you're there, tell them you're going to search it. Senator Bailey.
So, when you go in and execute a search warrant, I have I have never heard of a police officer reading somebody a search warrant. You provide them a copy. Sometimes when you are, I have done affidavits in some rather lengthy search warrants that are 20 or 30 pages, right? We'd be there an hour and a half to read it. That is for them to read it. The whole thing is, I mean, if you want to cover the liability of everyone involved, you want every police officer, right? This is a standard in the federal system already that says before an officer goes to a search warrant, they all are required to read, and they sign a piece of paper that they know everything that is going on in that affidavit. They know the warrant. In all seriousness, that is common sense. They should do it. But to go in there and then you've got somebody there and you're like, okay, now we have to read you this warrant before we can do anything. I mean, that is.
Well, what about something more? Obviously, give them the warrant and then just say inform them of the reasons. Yeah, provide them a copy. Provide them a copy.
Yeah, it should just be you provide a copy of the warrant to them, and then when you leave, you already have to provide them a copy of everything that you seized from their house.
All right. So
Right.
I say, but upon breach and once you secure provide them a copy. Is everyone fine with that?
Yeah, I don't have a problem with giving them a copy, but I do have trouble with the owner of the building. I mean, it's irrelevant in most cases. It's who's there, who's in the building.
I don't think, Senator Cassidy, I don't think they mean the owner of if it's an apartment building or multi-dwelling building, they mean the, southern management. I think they mean the owner of the residence or wherever you.
Yeah, I agree. That's what it
I
should
got
say,
you.
but that's not what
I
it
got you,
says here.
but-
It says the owner of the
Yeah.
building, and
Well, to Senator Casserly, there's a second Roman numeral there. So in number 2, it provides if the owner is not present, any occupant of the building, apartment, place, or thing specified in the warrant.
no,
So
I got it. But if I'm the owner of the building and I lease the apartment to you, I really have no right to say whether the cops can search your apartment. I mean, you're coming in through the common area. I'm not searching the common area. I have no business. It's the apartment, and that's your interest. I mean, I guess if I bust the door down, this year.
Yeah, just to be clear real quick before we go forward, we're having kind of two parallel conversations. One is about informing like the property owner or like the building manager, and one is about informing the person that is actually subject of the warrant. So I agree with you on the first part. Yes, we should strike that all out. That doesn't make sense. The second part, we'll just give them a copy, not read it, but once the scene is secure, so to make sure we're clear with that.
So the new language would provide that after securing but before searching, an officer would need to provide a copy of the warrant to any occupant or an occupant of the building, apartment, place, or thing specified in the search warrant.
What's the federal standard?
It would be to any occupant, right? And I mean, you can't walk in there. Well, all of a sudden, it can't be. There might be 11 people in there, so we better make sure to have 15 copies of this warrant, right? You just take a copy for there, and you give that copy to there. And the part about letting somebody's neighbor or somebody else in the building know about that there's no bearing or reason for that. Not to mention, I mean, if you go in and deal with somebody at your house, do you want the police are there? You don't want, if that was your situation, you don't want the police going to your neighbor and say, hey, by the way, we just did a search warrant on his house, and here's a copy of this, right? That doesn't, I don't think that makes much sense. We shouldn't be letting anybody else know, other than the people that are, where we are the primary residents of where we're going to search.
I didn't catch where that. I guess I'm trying. That's not okay. So, as for leaving the warrant conspicuously if the building's unoccupied, that's the next paragraph there.
You guys care about that?
I mean, I guess if I went in the building and nobody was there, and I searched it, and then
it's like after the fact. So like That's what I'm imagining. So just basically saying, hey, if you're not there and they've gone in, you come back and your place is trashed.
Yeah, I have no,
You
I'm
gotta-
leaving a copy of, if I went, there was no persons in the building, I searched
Yeah.
it, and now I'm leaving.
Yeah.
Yeah, I totally agree, maybe leave a copy of the warrant, but
That would be funny, you call police.
that was us.
Someone's been in here.
So what happens in a search warrant if the cops bust in my house, I'm not there, the door comes off the hinges, they search, are they they didn't have to stay there and secure the door, or what happens? I mean, my door's gone. And they didn't even find anything.
Say that again?
Yeah, so
Should
when you're
the law
executing a
enforcement
search-
officer secure the door before they leave?
Yeah, what happens? You guys,
We are public servants. Law enforcement officers are public servants. They can't leave your place unattended like that, so.
right, so what's the normal course? What do they do?
Well, if it's an apartment development, then they would contact management and say, hey, look, we executed a search warrant here, and we need that secured. Well, we'll figure out a way, but we're not gonna just
Okay.
leave it open, so.
So that's just normal course. We don't have to say anything
It's
about that. They
normal course.
automatically.
Would they leave-
Would they leave a copy of the warrant in the apartment for the
Yes.
person when they came
In a
back? So that's all this
conspicuous
is
place.
saying.
In a conspicuous place, yes.
Okay, thank you.
To go back to the notice provision, if that would be all right.
Yeah.
So if you're looking at page 3 of the bill, so like I mentioned before, originally this was drafted for all warrants, and the notice requirement in paragraph 2 provides that, it would have to be reasonably calculated to alert the occupants that the warrant was being executed. But then actually at the top of the next page, provided that it may be made before or immediately upon entry into the building, apartment, place, or thing specified. So I don't know if that addresses the no-knock consideration, since no-knocks are back in with the amendment. But I did want to draw your attention to it.
So that's the piece that's just saying you have to identify yourself. Like once you bust in, you just announce that you're a law enforcement officer. You just have to announce yourself.
It's no longer no knock, right?
Well, because you've already breached. It's after breach, though. It leaves you the option. It's or. So it's after you breached.
Look, not only a badge, but you're also announcing yourself. Once you do that door, you're announcing yourself. You better announce yourself for your safety and everybody else's. I mean, so.
Are we walking through that? We're not walking through that process in here, because the timing is out, right? The 30 seconds is no longer a part of this.
Hello.
So what's the time of events? I mean, where does it say that? You have to notify before you enter.
There's no notifying you.
Immediately upon entering into the building. Maybe before or immediately upon.
Well, I think it needs to be before.
But then that's not a knock. That's not a no knock. So you have to breach and then announce.
A no knock, you breach the door, and as soon as you breach the door, you yell, sheriff, police preferably, because sheriff sounds like a name. So police at the top of your lungs as you're searching through the house, clearing the house. When you make contact with persons in the house, you secure those persons, and you continue until you clear the entire house. Everyone's safe, everyone's secure, and then you said, I'm Corporal Jackson from the Office of the Sheriff of Prince George's County. We are here executing a search warrant for this premises. Are you the owner? If you're not, you and then you commence searching. But it's a no-knock, so you're through the door. That's the element of surprise to do what you need to do. But they are announced. And folks are identifiable when they come to that door as well.
It says after making entry, you see that?
Yeah, but why is it a may and not a shall?
To provide variability, because they could do it before or after.
Either or?
Right, so the shall actually comes, or the mandate, so let me read the lead-in language. So in A, police officers who is executing well, it's been changed to no-knock warrant, may not, for the purpose of executing the warrant, enter the building, apartment, or premises unless, and then it's that Roman 2, subject to paragraph 2, reasonable notice of the search is being executed has been given. So I guess it depends on, that would need to be altered to account for when, in the context of a knock and announce warrant, notice should be given and to what degree versus the no-knock situation. So we would need to change the language there. So the lead-in language for A1 and 2 on page 3, it says, as it was originally drafted, it said a police officer who's executing a search warrant may not, for the purpose of executing the warrant, enter the building, etc., unless, and then Roman 2 was subject to paragraph 2 of this subsection, reasonable notice that a search warrant is being executed has been given to any individual inside the building, etc. And then Roman 2 provided for what that notice needed to be. So that was that it needed to be reasonably calculated to alert the occupants of the building. But then it also said that it could be made before or immediately upon entry into the building, apartment, etc.
But so you'd have to add some additional language that says you could have this, but then you'd have to, but shall be made upon if it's breached. You know what I mean? That's what she's saying. So if you do breach, then you shall immediately.
On this is going back up where Jamie already read the last Roman numeral 2 on page 3. It says has been given. You can't enter unless notice has. It's a past tense.
Yeah,
that should be is given or something, because to say has been given says you can't enter unless notice has been given. It means
I think changing the lead-in language to maybe a police officer may not execute.
I'm looking up on A1. It says he cannot execute it unless, and then I come down to Roman number 2, notice has been, as in it's already been given. Then you've just defeated no knocks.
I think by changing that to no knock in the lead in, I think is probably going to need two paragraphs here, one for no knocks and one for every other warrant.
This was going to pertain only to no knocks.
That's the intent.
Well, it sounded like the committee was discussing notice in both contexts. Notice in the context of the knock and announce, and also.
No, Jamie, no, that's not. No, this is all the reforms only apply to the no knock. So
Okay.
Nothing should be touched. This has to be moved around a little bit.
Okay.
And I think it should say notice is given pursuant to section whatever, and then we go down and say not has been given but is given.
Our intent was not to touch the warrants, just the no knock, and that was it. So.
Yeah, let me. I might need to play with a little bit of the lead-in language to account for that.
Okay.
I mean, okay. Well, when we move forward, we can adopt that in concept. Everyone understands what's happening. We're not touching the normal warrant process, just the no knock. For the uniform. Roman 2B and down, or B1. So we're gonna have to add another line that says, if and something will, yeah.
Right, I think in every context there is going to be a breach made, since it will only apply to no knocks.
Yeah, so shall, just put breach then shall, not may, shall.
Gotcha.
Yeah, got it.
Yeah.
So a police officer, I'm looking at subsection B, a police officer participating in the execution of the search warrant shall wear a uniform or other clothing that makes the officer immediately recognizable as a police officer at all times while participating in the execution of the warrant, and may not, for the purpose of executing the warrant, enter the building, apartment, etc., between the hours of 10 and 6 a.m. Unless specifically authorized in the search warrant.
So, and like, hey, I need you, the other two senators, Jackson and Bailey, because I need your, listen up on this, because my concern is, I would expect that if you're doing a no-knock warrant, you probably have some officers who are plain clothes or in the vicinity, just as catching intel before you go in. So they're participating, but they're not going to enter the building. And I think what we really want here is the officers who are actively entering the building to have, those FBI jackets or police jackets, but the three officers outside who are providing early perimeter security to make sure nobody else had come in while they're participating, there's no reason for them they could still be plain clothes, right?
That's certainly the intent, by the way.
Okay.
So,
They should
That is
be,
the
they should be in plain clothes and completely covert,
Yeah,
especially
yeah.
if they were surveillance
Okay, so we're just going to cover
that
the
type of
cops who
thing.
are actually breaching have to have
And-
those jackets or something that says
and-
police.
We just call them raid jackets,
Okay,
right? You'd have to have your raid jacket on.
yeah.
well, just it's something that's identifiable. I don't want to use.
Yeah, and then and they wouldn't normally put those, I mean, if you got like a line of 10 cops, they're going to be the raid force, they're going to probably go into the apartment building without their raid jackets on, then they get in the hallway outside, put their raid jackets on, and then enter, right?
The intent here is entry, correct?
Yeah.
Yeah. So instead of just
It's entry, upon entry.
It's the entry part where the jackets have to be
so
there.
then do you have to put would you put another subpart there and just say, or would you put it up front saying the
But you
officer?
can't enter the premises, you can't enter the place to be searched without a raid jacket on.
Yeah.
Is the gist of it.
Yeah. Do you understand what we're saying?
I think I'm going to need to rework the language, but you're saying that if they're making entry, not just if they're participating, because they
Yeah,
may
because I
be,
got cops outside on security, and
Right.
then the cops on the or the cops doing the warrant are all gonna come in dressed like this, gather in the hallway outside the apartment, and then everybody's in, then they're gonna put their raid jackets on and execute. And so we don't want somebody saying, oh, the whole search was unlawful because they were participating without
Right.
wearing police jackets,
so it only applies to the officers making entry.
reaching, right, into the
Yes.
area to be searched.
Gotcha.
That's it. Yes, so for the officers who are making entry, they need to have uniform and other identifying law enforcement clothing. That's it, just for them. I'm sorry. So for those who are making entry, you shall wear a uniform or other identifying law enforcement clothing. That's it. It's just for the ones making entry. That's it.
Why wouldn't it be good enough if they just had a big badge on? Other identifying, yeah, emblem or something. If they got one of those badges on around their neck, that's fine.
Can I ask our dear law enforcement officials a question? When you do a no-knock warrant right now, do you have to wear any uniforms now?
You are supposed to, yes, ma'am.
You
That's
have to
according-
wear something, right?
Look, I think that part of the challenge is here, we're trained to do that. That's how everyone is trained to do. Now, if it's not occurring, we're just re-emphasizing it in law that this must occur.
Well, I think they should wear some kind of
Oh,
identifiable
absolutely.
something.
It's for safety, not only for the folks that are in the house, but it's also
So
for
they
the
know
officers.
who is law enforcement, who's not,
Yeah,
right?
you're coming into someone's house unexpected
under
and
this-
unwelcomed.
Under this provision, can you just be like regular clothes, but you have a raid jacket? Would that qualify?
Well, you say law enforcement uniform or other, law enforcement identifiable items, which could include badge.
But
which
if you
could
had regular
include-
clothes and then you had the jacket
include-
on,
yeah.
that's okay, right? Would that
Yes.
qualify?
Yes,
As long as the public knew you were law enforcement, right?
yes, ma'am.
Okay, thank you.
So then the second piece, I'll ask again, we had a little bit of a conversation about this, but the time restrictions, unless otherwise authorized by the warrant, I mean, that just, again, makes it clear that there's some sort of discussion about why you're going in the middle of the night.
So my question is, and I was talking yesterday about this, 6 a.m. where I come from is definitely not the middle of the night. So I don't know how steadfast we are on 10 to 6, because, I mean, if you were to go out on my road in front of my house at 5 o'clock in the morning, it's a highway, right? People are gone. So I know that we could do it, but the way I am understanding this 10 to 6 is just involving no-knock warrants.
That's right. So, but again, you can still do it. All you have to do is say exactly why you want to do it. And it's not, I mean, it's just to force that discussion.
So as long as they sign off on it. Okay.
All right. So everyone understand. We don't obviously there's some corrections that we've made through there to clean up the bill and move some things around. But does everyone understand, what we have before us? Any other questions? Uniforms, time of day restrictions, the process of approval, procedures for entry. Anything else?
I did want to point out. So, just to clarify, because obviously the writing of the amendment didn't hit on this, but the provision, there was a provision where the judge could restrict the time, place, and circumstances of the execution of the warrant. Should that also apply? That should just be to no-knocks as well.
Yes, that was correct. All right, so is everyone just okay with adopting this in concept so that is all we're working on? It should be, at that point, it should be something when we come back, we can just vote on it. I wanted to do it tonight, but I know. Senator Hettleman, then Senator Castley.
Thank you. Did we put something in here reflecting the earlier discussion about how much notice we want it between when they get the warrant and when it has to be executed, or we're leaving that to the discretion?
No, it's 15 days right now. I think it's still 15 days. I was doing some research on what Virginia just did, and we had discussions. I said 5 and then 7, and then we talked about, well, what about a weekend? And so, I mean,
What did Virginia do?
they had 15.
I think that's a lot.
I think that's a lot as well. I mean,
Of the operation. So, it may take 15 days, but in many cases, it could take a lot less.
So that's not, so what concerns me is that things change. I mean, we've seen this time and time again, that facts on the ground, I mean, I don't need to tell you this, but it seems to me that, people's situations change a lot, and what you might understand when you execute that, or when you fill out the paperwork, changes in that period of time. So I guess these are by definition kind of exigent, so it seems 15 days that's a long time.
2 weeks, I mean.
Yeah, I mean, unless you've got, I don't know, and maybe the officers could speak on this, that I don't know how these warrants, I mean, I imagine these are specialized squads that do this. You've got to line them up. But if you've got, let's say, a drug operation where you've got, the police have identified 10 different houses, and I don't know how much in certain high crime areas that are warrants, the warrant squads are doing and everything else, but it seems to me like it's a logistical thing.
So it is, now remember, we're just talking about no-knock warrants. So these are the most dangerous warrants for not only the officers, but also for the people that are, the residents that are there. And having been on a lot of warrants, I can just tell you that the main thing you want to do is make sure that everybody comes out of there safely, as best as possible. So the scenario is, when you're planning one of these and you get it signed by the judge, As soon as that is signed by the judge, then that puts everything in motion, because you can't do that beforehand, right? Because the judge, when he looks at it, depending on the judge can say, you know, I want this, I want you to go back and do some additional information in your affidavit. So when you go back and you have to do that, it might take a little bit of time. So you can't have everything set up. Now you're talking about if you're going to do a no-knock, you're going to use a SWAT team. You're talking about changing people's schedules. These people, very few police departments have their own dedicated SWAT team on standby ready for this. So you have to change schedules and time to make sure this works. And then the other part of that is, by this time, you know who you should know and have a pretty good idea of who the bad guy is, right? Or who the bad people are. So when you're dealing with that, and then remember, life happens. Snowstorm, just like what we're having right now. Things can all get back and forth. The thing is, 15 days is what we have right now. The part of the bill that we added in was a reporting requirement. And now the reporting requirement would require the department to put in the governor's notice the fact of how many days from when they got the warrant to when they signed it. So I don't think there's any reason for us to come up with an arbitrary date right now and say, well, we think it should be 5. We think it should be 7. We should make this information, if we need to address this, based on information that we learn, because we haven't had any of this data come in since 2018. And I think that's the best plan.
Were you ever asked by the judge or the state's attorney, like, to do additional reconnaissance in that time period? Because it seems to me, I totally understand the logistics. I get what you're saying, and I appreciate that. But I'm also looking at, do you ever, I mean, the circumstances might change on the ground. So are you ever required to report back to a firm that what your assumptions were when you went in there still hold 2 weeks later?
Right. In some cases, you know, we may apply for a warrant and anticipating in this 2-week window that I get this team together to be prepared for this. What is the best time to execute this? Are we going to have the subjects there? And things change. Sometimes you have to go back to that judge and says, you know, we had until this period of time. We're not going to be able to execute this on this period of time. Then you have to reapply.
Usually that entire time between when you request and when you execute?
People, residences, whatever that's associated with the target, the crime. Yes. And so you have folks who are working, and it depends on the size of the agency. Are you working with another agency? So there's a lot of things that come into play. The key is you need to know that what are the best chances of you being able to find the evidence, find the person, stop whatever that's going on, that you have applied to this judge to say, this is what I need. And so that's a timing issue. But also with regard to folks who actually execute these, if no-knock warrants, you have SWAT team folks, there's also written in the law, in the Maryland Training and Standards Commission, it's also written at how long you can have these folks activated. There's an attention to detail component that comes into that. So you can't have the SWAT team, this team over here just executed a no-knock warrant down the hall, and then all of a sudden you're turning them around to do something else. They've got to have downtime, they have to have debriefing time, you have to make sure folks are are prepared. And so this is a logistical challenge for agency heads, for members of the agency, as Senator Bailey mentioned.
I get that.
The scheduling and making sure you have the folks. And again, we had the monitoring piece here. So we can take that and we can look at that within a year to say, you know what, these guys are doing this within 7-8 days. You know, if that becomes a challenge. I don't really think it's a challenge. I think it gives us a window to execute this court order that you've been granted.
I'm done. I mean, I totally appreciate, I understand. I'm just, facts, and this happened with Breonna Taylor. I mean, the situation changed while, they were doing their, so I just, all I'm saying is that, that interim time, just want to make sure that the surveillance or reconnaissance is done to better inform everybody.
Put what in?
I don't have any opposition to a time limit on these, because they are, I think you said, they were, by definition, exigent circumstances, because you said had to be no-knock, so it's not like the typical. I didn't have a problem, and we can discuss a time, but to specify, you make a valid point. I'm not.
I don't want it to be arbitrary, but it seems to me it's more important the reconnaissance, right? And the updating of information between when it's requested and when it's carried out. That's my only point. Yeah.
So we can kind of do this, look, there are folks who are responsible for these, so you do have a surveillance team or your investigators. That's their job. You can't have folks coming in blind. I can't have a team of folks coming around the corner in a truck to execute a raid, and we are not sure that as best as we can that target is where it needs to be. Now, there are also cases, either human beings who are, I'm not going to question whether they were supervised properly or whether they did whatever. But, those details of how SWAT teams operate, and we can certainly get you the information on that, the finest detail down to the minute seconds of when you breach, when you do everything. But they have to have the information. The observing officers need to let you know just before you go in exactly what they're seeing. And every bit of that is documented. Every bit of it is documented. And it's transmitted. So, because there is a debriefing that occurs there. So it is in great detail of everything that occurred on that scene. So.
Thank you, Mr. Chair. I don't see the 15 days in here at the moment.
It's in the statute, so.
It's in the current statute?
Correct, yeah. I'll bring it up.
Okay. Have you all had any problem dealing with the current statute, the 15 days? Okay, I have no problem with it then.
All right, so is everyone cool just adopting that in concept, and then that'll be what we work off when we come back?
Yes.
All right, shouldn't take, nothing takes 30 seconds on this committee, but it shouldn't take long when we come back. Yeah, we'll get it'll be just one thing.
No.
Sorry.
It's still now criminal and public safety.
Oh, you want to move it to the different section, that's right.
Yeah, I hate when that happens, because anybody who comes down the future and wants to reform warrant stuff.
So you're saying put it in 1-2?
Put it all in criminal procedure, because that's where the warrant stuff is.
Yeah, 2- this one.
Yeah.
1-203.
Yes.
Well, that section talks about the issuance of search warrants. And I think it was put in public safety because the execution was going to be done by law enforcement officers, so it was put under that subtitle.
Yeah, I know why they did it.
I know why they did it, but I know this is minor, but if you ever try to change warrant stuff, it's just better to have it all together in the procedures dealing with warrant than getting into public safety, which is, I know that's police and police training stuff, but it's just going to make it painful for anybody down the future that wants to do stuff on warrants. It's just better to all be in one section.
Reporting requirement, though, could we leave that in the public safety article?
Yeah, that's fine.
Okay.
I just want the need to be in.
That's fair. Okay, yeah. All right, so we've adopted that in concept.
Get up and grab those toys.
Yeah, that's exactly right. All right, so we'll adopt that in concept, and it shouldn't take long. If everyone's in agreement, then we'll vote it as soon as we actually have the language for it. So want to make sure that everyone has a piece of paper before we vote. So, okay, let's move on. Do you all need like a 5-er bathroom break, just stretch break, walk around break before we go to body cameras? We need just take a 5-minute. I'm just taking the temperature.
While we're deciding, I'm just going to take a walk.
There you go. Let's take a 5-minute. Just take a 5-minute break. Senator Carter just decided for us. All right, 5-minute break. Sorry. All right, you guys all ready to kick back up? So we're working off of Bill, what, 71? Is that right? All right, body cameras. All right, so council's going to explain the bill, and then I guess we'll turn it over to Senator Sidnor to open us up with the comments and give us a little bit more background. All right.
So this is Senate Bill 71. As drafted, this bill provides that the knowing and willful failure of a police officer to activate a body-worn camera in violation of the policy of the law enforcement agency that employs the officer creates a rebuttable presumption that that any testimony of the police officer sought to be introduced in a criminal prosecution relating to the incident that is not recorded is inadmissible. As drafted, the presumption could be rebutted by showing that the body-worn camera was not activated due to a malfunction of the camera, the police officer was not aware of the malfunction or not able to fix the malfunction, and the law enforcement agency's documentation shows that the officer checked the functionality of the camera at the beginning of the police officer's shift. There's an amendment that was just distributed. It is 268072. And this alters how the presumption can be rebutted. The presumption could also be rebutted on a showing that it was unsafe, impractical, or impossible for the law enforcement officer to activate the body-worn camera. There's also a provision in the, just below that, that's being added in the public safety article. It's 3511. And it adds a provision that on or before July 1st, 2022, the Department of State Police, Anne Arundel County Police Department, Howard County Police Department, and Harford County Sheriff's Office shall require the use of body-worn cameras by each law enforcement officer employed by the agency who regularly interacts with members of the public as part of the law enforcement officer's official duties. The next paragraph provides that on or before July 1st, 2024, a law enforcement agency other than an agency that I just described would need to require the use of body-worn cameras by each law enforcement officer that regularly interacts with members of the public as part of their official duties.
So, Jamie, I remember this conversation. Just actually, Senator Sidnor, you want to go ahead and we'll start?
Sure. I just had a conversation with Senator West during our break, and wanted to make clear to the committee because, I mean, again, after reading the testimony that was in opposition to this bill, I wanted to focus on the words knowing and willful, because a lot of the testimony was about split-second things happening and people making simple mistakes and things happening or assaults happening in progress in an instant, the officer having to do something. This bill isn't about mistakes. It's not about things happening instantaneously. This bill was put in because we had incidents where officers were knowingly and willfully not turning their body cameras on for whatever reason, for whatever reason, and it was problematic. There's been, in fact, I was contacted by our local public defender's office about a case that had happened in Baltimore County, where something like this is thought to have happened. So that's what we're trying to get at with this bill. In looking at the second piece of the presumption, number 2, it was unsafe, impractical, impossible for the law enforcement officer to activate the body-worn camera. Again, I'm not exactly certain how that might affect this bill, but again, that's not what this is about. I think the rest of the amendment makes sense because I'll say in the work group that I had sat on, it seems like law enforcement is moving in that direction. A lot of our police departments, they're looking to have body cameras, and I kept hearing the date 2025 or 2024 or whatever. So I mean, it seems to be in line with that. So I'm fine with that. But I would love to hear a little bit about the unsafe, impractical, or impossible.
So do just Senator West and Senator Sidner, and then we'll come to Senator Huff, because I know you probably have concerns about the mandates.
Okay, so I had a conversation with State's Attorney Schellenberger in the last 15 minutes, and he indicated that if that second rebuttable presumption were added to the bill, he would be comfortable with the bill. Now, and of course, we all know he's a big fan of body cameras. It was in my omnibus bill. The only difference between this really and what was in my omnibus bill is my bill suggested that the state should pay half the cost of the initial body camera equipment in order to make it less onerous on the counties and municipalities that don't have it. And I would be happy to put that into this bill, because I suspect when we hear from Senator Huff, we're going to find that in his legislative district, the cost of the equipment will be hard for the municipalities to bear.
All right, so can we just, before we move on to Senator Huff, can we just stick to the presumptions and see if we can figure that out, and then we'll move over to the cost.
What did Senator West mean by the second rebuttable presumption? You lost me when you said that. You said the second rebuttable presumption. What did you mean by that?
As originally submitted, there was one rebuttable presumption, which is found on page 2 of 2 in the reprint between lines 11 and 20.
Right.
And so this bill adds a second rebuttable presumption.
I'm sorry, the amendment does?
Yeah, the amendment adds 2 more lines. The second rebuttable presumption would be if it was unsafe, impractical, or impossible for the law enforcement officer to activate the body-worn camera. It responds, I think, directly to Mr. Schellenberger's example that he gave of two policemen sitting in their car, and some guy walks up and shoots one and kills him, and the second one, the only witness to it, would be unable under, theoretically at least under the original bill, would have been unable to testify because he didn't turn his body camera on. And Scott's argument was he didn't have time to. So the second rebuttable presumption is designed to make sure that in situations like that, where it's just impractical or unsafe or impossible to turn the body camera on, that there is no prohibition on using the officer's testimony.
Okay, so it's not a second rebuttal. It's your second defense. The presumption is rebutted by that evidence.
Fine.
Right. So the presumption, if you show that evidence, the presumption is negated, and you move forward. Okay.
So Senator Serno, I'm not clear where you stand on. So Senator, can we go to Senator Serno, and then Senator Carter?
No, in that example where an officer's partner is shot, I don't see how the officer's testimony or evidence doesn't come in. Because there's no knowing and willful failure. Again, this is something that's meant to deal with officers who are purposely or knowingly not turning their body cameras on. I don't see. For the life of me, I don't see how that doesn't come in. Just because you did not have time to turn it on because you were attacked in that manner.
Well, if I could respond, if I were a good defense lawyer, in the case of Mr. Schellenberger's case of the two policemen in the police car, one of them gets shot and the other one is not shot, but he doesn't have his body camera on, from the second that the shot rang out, he could have turned his body camera on, but he didn't. He was so consumed by the activities of the moment that he didn't turn the body camera on. So you could argue, good defense counsel could say, you knew you had the body camera, you knew you were supposed to turn it on, you didn't turn it on, did you? And the policeman would, I don't know how he'd respond, but I can see the defense counsel making that argument. If you have the second part of this in there, saying it was unsafe, I mean, the guy who came up had a gun, he would have a much stronger case as to why his testimony should be able to come in.
So I agree with Senator Sidnor. That doesn't seem to be necessary, and I'll say why. The bill specifically says that this willful failure to have the body camera on is specifically in violation of the policy of the law enforcement agency. In a situation where they're sitting in a car, ostensibly on a break or not in official duty, I don't think that would be, well, I don't think, I know, that would not be a violation of the policy or law, so it wouldn't apply. So I think that's just superfluous. It's not necessary.
Well, in trying to come to a consensus on this piece of legislation, is there any problem with including that language? Is there any reason why that language would in some way hurt the intent of the bill? I think if we include that language, you're going to get the state's attorneys in support of this bill. If you don't,
well, that's my goal. That's actually so. I mean, it's not worth really going into it. It's just not necessary. And we've had a lot of debate about whether or not we need to add additional language in bills that are unnecessary. If that's a policy that we want to adopt, that we just add things to make people feel better or more comfortable, even if they're not necessary under the law. If that's how we want to make law, then that's a decision we can make. But if not, then I would say that we don't need that language.
well, I just gave you the argument a good defense counsel would make. So long as this will bring us together, and it doesn't hurt the intent of the bill, I don't see any reason why we shouldn't include this language in the bill.
Thank you. I was just looking. It says an act is, and this is with regards, I'm looking at a Department of Justice page on a criminal resource manual about knowingly and willfully, and this is talking about in a case about fraud, and it says an act is done willfully if done voluntarily and intentionally and with the specific intent to do something that the law forbids. There's no requirement that the government show evil intent on the part of the defendant in order to prove that an act was done willfully. I mentioned that just because, again, that circumstance or that example, I don't see where it rises to an officer that's knowingly and willfully failing. Now, my point, though, and hopefully maybe this group can help me to understand, is in adding this, what is it that we're trying to do? What I don't want to do is say, all right, that sounds good, if it's going to ultimately end up harming what we're trying to do. That's what I don't know. So I'm trying to understand how it helps.
Since, look, we have an amendment that has basically, four parts to it, two real parts. So we're going to take this and we're going to, vote it up or down, and then we'll move on to the actual mandate piece. But go ahead, Senator Cassidy.
Yeah, it's just listening to the testimony. It sounds like what Senator Sidnor, the way you described knowing and willful, that he means intentionally. So, and then if it's an intentional, it's not a failure. It's an intentional refusal, intentional act of violating a policy that has you turn your leave your camera on, or if he intended to do it, then I'm not sure why we have the presumption. I mean, because then a officer's going to say, well, I can rebut that by showing that it was broken, but then you didn't intend to do it, or I was unaware of the malfunction, but then that's not intending to do it. So I'm not sure I'm just trying to simplify this bill a little bit, because the presumption, I'm not understanding why there's a presumption, unless knowing and willful is not really intentional. Because this has a knowing and willful failure. So, look, you were just careless. Is that a knowing and willful failure? I got out of my car, and yeah, I should have turned it on, and I just didn't do it, and is that a knowing and willful failure? I'm not sure if we mean intentional, is what you said, then it should just say, the bill should just say a police officer intentionally, as the case in the, where we see these cases where they show that they turned the thing off because they didn't want to see the interrogation, or they didn't want to see that the something you intended to obliterate part of the evidence, which sounds like where we're going. So then I don't see the reason for the whole rebuttable and presumption stuff. It's just if a police officer intentionally turned their camera off, with the intent of not filming something in violation of their policy. That's just my thought on the bill. Thank you.
Do you have Senator Sidnor, you have anything else to say on that, or no? Senator Carter.
Thank you. Senator Castley, and maybe I'm wrong here, because I like to simplify the bills too as much as possible, but you can correct me if I'm incorrect, but I don't know. My assumption was that the rebuttable presumption is that it's not done. The camera wasn't on, and so there's a presumption that it was done in violation, but it's rebuttable by the officer producing evidence that it wasn't intentional, willful, and whatever. Right? So I don't know if we achieve the same thing without rebuttable presumption. But
if the standard was that, let's just say hypothetically that the bill said the failure of the camera to be on in violation of the rules creates a rebuttable presumption. Was the camera on? No. Okay, we're going to assume that you were trying to hide something, but you can rebut that presumption by showing us that your partner just spilled coffee all over you, and you were getting out of the car because you had hot coffee in your lap, and the camera was malfunctioning or whatever. But unless the burden just shifted to the officer to say, your camera wasn't on, we're going to presume that you were acting with bad motives, and now the burden shifts to you. So I understand that use of the presumption. I'm not advocating to do that here. I'm just trying to simplify the law. It seems to me that what we're really saying here is that if the defense shows that this was, if they can convince the trier of fact, this guy was screwing with this stuff, then okay, you're out of here. You can't. Don't be coming in now and saying, yeah, but I turned it off. But you know what? He did have the murder weapon, and he did say I did it. It's like no. We already established that you turned the camera off to manipulate the evidence, so you're out of here. If that's what we're trying to get at, then it would just be intentional. I still go back to my original position on this, which is we ought not be applying the exclusionary rule here, because the defense lawyer is going to come in and say, your camera, the department said turn it on, that's your policy, you had a camera, we spend $100,000 a year to give you this camera, and just so happens that you say to me you always use it, it's your policy, but just at the point where you say my client confessed, your camera wasn't on. Yeah, right, okay, look, that guy's walking, it's just, nobody's going to believe this, his credibility is shot, and then he's all subject to administrative penalties because he didn't follow department rules, leave the camera on. So I just don't see, I didn't hear the case come up that said, oh gosh, unless we have an exclusionary rule, and as we discussed before, I mean, exclusionary rule was imposed upon by the Supreme Court, and people didn't like that because they said, you found the murder weapon in the car with his fingerprints on it 2 seconds after the murder, but you violated his Fourth Amendment rights, so we're not going to let you introduce that. And when you do that, you just let a murderer, rapist, evil person back on society, but they say, yes, but the Constitution is so important that we have to do that. You're like, wow, that's a pretty high, I mean, hey, it's, okay, I got it. That's the decision's been made. But I'm not sure we want to apply that. That's a pretty serious outcome for body cameras. I'm all in favor of body cameras, and we should, demote cops, fire cops, argue that he was dishonest, all that if they're going to manipulate the body cameras. I'm just really hesitant to go with exclusionary rules because it's just it's such an extreme measure that the Supreme Court adopted just to keep police from beating people, interrogations out of them, and violating their constitutional rights. And they said that's the only mechanism we have. But it's so extreme. And I'm not saying it's not a good decision, but it's there because the goal is so high that's why that's there. Thank you.
That was excellent. Thank you very much. All right. So, Senator Bailey, I think you were up next.
Or, we're not, I was going to speak on the amendment as I read
So
it.
I want just this piece of the amendment. Yeah. Yeah, that's what we're going to be voting on next. So
We are on the,
we are on this portion of the amendment.
okay. But not the part where it C11, we're not there yet?
No.
Okay. Okay, I'll wait on that.
So keep on the, all right, so let's do this. I think we should just take this piece by piece because this is pretty simple. You just go in order. So, you're talking about underline 20, or just we'll call it the West language. So page 2 of 2, underline 20. So, just someone, Senator Russ, you want to make a motion? All right, hold on. Before we do that, Senator Jackson.
So, I guess to direct you to the maker of the amendment, I'm actually looking at, when you look at the bill, it talks about willfully and willful failure, and I think this is part of the defense under Amendment 2, where it's unsafe, impractical, and what. I think it's part of a normal defense of, why didn't you do X when you're questioned by your supervisor? That's part of your normal defense, but I didn't have the opportunity to do that. So are we trying to say that this would equate to someone willfully not activating their? Is this what this amendment is doing, or is this giving a reason why they wouldn't have done it? Because I think the bill says willful failure.
To begin with, I read the amendment for the first time 5 minutes ago, just like you did. So I'm not sure why it's being described as mine, although I agree with it, because I had just had a conversation with State's Attorney Schellenberger, and he said he could not support it as written, giving his example, the 2 policemen in the police car, but he said he could support it if we added this additional language. So when I saw the amendment, I said, great, we're there. And now we're going to get the state's attorneys on board on this bill, and we should all achieve a consensus. So the argument is that based on the original language of the bill, where it just says knowing and willful failure, in a situation like the one posited by Scott Schellenberger, 2 policemen sitting in a police car, this guy approaches the car, takes out a gun and shoots one of them in the head, and the other policeman, at that point, it was like all hell breaks loose. The other his partner's been shot in the head. He's grabbing his a walkie-talkie or whatever you call it, and calling, "We need help! We need help!" Whatever the code is for policeman down. He gets out of the car. The perpetrator's running away. He's running after him. He's got his thing in the, come after me! Help! I need help! I need backup. And when they get to and finally 5 minutes later, he catches up with the culprit, and for the first time sees his face as he tackles him. Now we get to trial, and the defense counsel in trial is going to say, you never turned your body camera on. Look, you had 5 minutes to turn the body camera on, and you didn't do it. That was a knowing, you knew you had it, You knew what the rule was, but you didn't turn it on, and therefore your identification of the culprit cannot come into trial. So this second provision that's just been added gives him another argument that he can use as to why he didn't turn it on. It was impractical. He was busy trying to catch the culprit, and his mind was on other things, not on turning on his body camera.
Appreciate your response. So I certainly understand, exigent circumstances on the street or, while you're working as a law enforcement officer. I think that's part of your defense and the prosecution's job to make sure that, these were the details of the incident. So defense counsel will probably come in and say that Mike Jackson didn't turn on his equipment, and and we'll be prepared for that because everything happened just like that. I'm reading the bill to say, if I intentionally not turn it on, not that if I'm not incapable or the circumstances doesn't lend to that. Unless I'm reading the bill wrong, I think the bill is saying that I am purposefully not turning this on. That's what the bill says to me. I think you already have an excuse. Look, there are a lot of things. I mean, we have a force, continuum, right? Which means presence, verbal, hands-on, spray, baton, everything, and before you get to the weapon, till you get to the deadly weapon. But if circumstances dictate, I'm not really going to be able to do all those things. But I should be able to articulate why I did not, or I was not able to do that. I would love to have had every intent not to pull my weapon out and fire my weapon. I'd rather have, if I had to arrest the individual, to have the person turn around and put their hands behind their back. But the circumstances didn't lend to that. But I didn't purposefully just pull out my gun just to shoot him, just to do it. I think the bill is saying that I am trying to cover up a criminal act, possibly, to frame a person, possibly, and I think that this language here in Amendment Number 2, I mean, and the circumstance, I mean, I think that is easily, it may take some time, but I think it's easily explained explained by the prosecutor and explained by the officer. I mean, if something happens, if I don't have time to do that, I mean, because I'm not walking around all day with the camera on. So that's my perspective of the bill. And I'm not sure that, this amendment gets us there.
I think we may be ready. So I'll give Senator West one more chance to respond, and then if you've got the motion, you push forward. You want to respond?
Well, I've explained a couple of times. Defense counsel's job is to get people off. And defense counsel will seize on whatever language in the law defense counsel can to get the client off. So whenever the body camera wasn't on, defense counsel is going to say, you knew what the policy was, didn't you? And the policeman's going to have to say, yes. You knew you should have turned that body camera on, didn't you? And the policeman's going to have to say, yes. And yet, knowing that, you didn't turn the body camera on, did you? And the policeman would say, yes. And defense counsel will turn to the judge and say, this police officer knowingly and willfully failed to turn the body camera on because he knew what the policy was and he didn't do it. And therefore, his testimony about the identification of that murderer, the guy who murdered his partner, cannot come into this trial. And that will give the judge the opportunity to make a ruling, and depending on the judge, the ruling might be, that's right, the murderer goes free because of this language in the statute. So the amendment adds additional language to give the police officer additional grounds, the prosecutor, because police officer won't do the arguing, gives the prosecutor additional grounds to argue to the judge that this evidence, the oral evidence of the police officer can come into the trial because there is no body camera evidence.
All right. So Senator Carter will have the last word on this, and then we have a motion that I think has been seconded. So
Thank you, Mr. Chair. I just want to briefly say that both you and I think, well, you, Senator West, I'm not sure if Senator Cassidy said the same thing. I think you did. In supporting your argument for why you need this language, you've talked about defense counsel, and yeah, some people have very savvy defense counsel, but the reality is that not every single criminal defendant in a court has any counsel at all. Some people are actually pro se. Some people have public defenders with hundreds of cases. And so, I don't think that we legislate to what a defense counsel might do or what we think the best of the best defense counsels might do. I think we legislate based on the best black letter of the law. And so why I don't think the language is necessary is this is about a rebuttable presumption, and the things that you're saying, impracticality or impracticability, unsafe, those are those things which would rebut the presumption. And I'm concerned about specifying these are the things that would rebut a presumption. I think we should leave that open. I don't think that we should specifically spell out those very narrow things. And I also don't think we should legislate to what we believe the best defense counsel do, because not every criminal defendant has one.
I'll just say this real quick. So look, I think the way the way that this bill is drafted, the jurisdictions could develop a policy that would do just this anyway. But to Senator Cassidy's point, you're talking about preventing an officer from participating in an investigation because of there's a malfunction or there's a knowing or willful obstruction of the body camera being on. That's a big deal, especially when I thought, look, I don't agree with the person that gave us this language all the time, but I thought he made some pretty strong arguments here. That's why I had it drafted up, to be fair, Senator West. These are my amendments, but for discussion. But it's like, if you're going to exclude this from being able to the officer from being able to testify because the camera was off, it's a big deal. And so I do understand what West is saying when you say that I don't think there's anything wrong with this language. If you can knowingly and willfully refuse to turn it on because you're rendering assistance, or you're running away, or you're trying to wrestle someone. So I'm just trying to figure out. I've been trying to figure out what's wrong with it, but I don't think there's anything wrong with it. Yeah. All right.
So I knew I had to do it, and there was no reason.
I
for
knew I
me
should have
not
just
to
shut
do
up.
it Other than, I said, why didn't you turn your camera on? I don't know. Well, I want I'm not sure why my county ended up here, one of 3 counties. So
I'll explain that in a second. So it's been seconded. So we're only adopting. It was unsafe, impractical, or impossible for the law enforcement officer to activate the body-worn camera. That's before us.
That's all we're going to vote on, is that safe or impractical language.
That's right. And the motion has been made for favorable, and it's been seconded. So is everyone okay? I think we need a roll call on that. Is everyone okay with that? Let's do a roll call then.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Can you come back to me? Just a minute. Can you come back to me?
Senator Cassidy.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
This is a safe and practical language, Bob, or Jack.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator Lee.
Yes.
Chairman Smith.
Yes. All right. So that portion of the amendment's adopted. So it's the safe, unsafe, and practical language adopted. Okay. Now let's move on to Senator Cassidy. You had a question. I think that's the next portion of the amendment deals with the jurisdictions that would be required to have body cameras by a certain date. So I just put this out for discussion. So I from the hearing and from our work group or whatever, from the hearing, that was where the first language came from. The second language is this, that if the goal is to have every jurisdiction to have body cameras by a date certain, these are the next, so right now it's Baltimore City, Montgomery County, and I think one other Baltimore County, right? Three, you do have them. Yeah, 3 jurisdictions have them. Yeah, Montgomery, Baltimore County, Baltimore City, 3 jurisdictions have it. So, and Prince George's is in the, I guess, in the midst of doing it. Anyway, the point is to have the next 3 largest jurisdictions have them in a somewhat accelerated moment. And then, yeah. No, I hear you. I'm just putting this out there for discussion. And then,
And Gaylor came to a deal, and they're rolling out, and they budget them. But I wouldn't want to put in here a date that's like, geez, we had 6 months later or 1 year later, we had this done, but you guys screwed it all up. So I just.
You guys, I love you guys talking, but just keep talking. I can't hear anything.
You just put me in a tough spot here because I know we've got a schedule and they're rolling them out and they've budgeted. But you've come in now we've kind of jumped the gun here and said I can check with the county, but I'd hate to push this thing and then have them. Yeah.
So I think another piece.
I'll be talking to Gaylor, but.
Well, another piece to talk about is that as Senator West, we talked about this a little bit earlier about ensuring that the state picks up a portion of it. But I hear you. You haven't talked to the county.
The sheriff's office, which is
yeah,
and which is important to me because they're podunk. I didn't say that. It's not on the record. They're much smaller. They have much smaller budgets than the sheriff's office, which does the big crime stuff anyway. So and the county jumps in behind them, but not behind the municipalities, which mostly do traffic control and the like. So but I just need to call the county executive and see where they stand on the funding, which I'll do this afternoon.
Yeah, again, you guys may have missed it. The only reason those 3 are mentioned is because they're the next 3 largest jurisdictions that don't have it. So Baltimore City, Baltimore County, Montgomery County have it. The idea was to have the next 3 largest jurisdictions or counties get it in somewhat of an accelerated manner. So, all right, got it.
And then my next was really more of a question for council, which is, I'm just trying to understand the knowing and willful standard, and what would constitute knowing and willful. I mean, if it's not intentional, it's knowing and willful. And I don't know if that's defined in the criminal. I was just looking for pattern jury instructions on knowing and willful, and I can't find anything. Yeah. But if you could establish knowing and willful by saying you knew it's a policy, you're sitting in your car, there was nothing to prevent you from doing it. You should have turned it on when you got out, and you didn't do it. Why didn't you do it? So I don't know. Have you established that was knowing and willful in the defense? I mean, does that? If I can't, I just didn't do it. Well, and then the fact finder says, okay, that's knowing and willful. We gave you the camera, everything was ready to go, and you were too busy eating a donut, and you got out, and you didn't turn it on, and that's knowing and willful failure to do it. I don't know. Does that satisfy it? I mean, that's different from if the cop's saying, oh, I'm going to screw this guy. That's totally, but that's not knowing and willful because otherwise it would say intentional. And this isn't intentional, it's knowing and willful. So what's the difference?
Yeah, so we don't actually define either of or any of those 3 terms, I don't think, in the code. That's all through case law. Let me pull the definitions.
I get some other circuits and stuff, but I wasn't coming up in Maryland. I just want to understand what we're holding, what the standard is, to really understand how that's going to be interpreted when we say that.
Let's come back to that at the end. Pull it back. Okay, so then so that takes care of that because folks need to check with their local jurisdictions about that. Before we move on to the next part, which is everybody, is the state police. Is everyone okay with the state police? Yeah. Okay. And then we would obviously we pay for that. Senator Bailey.
So when we talk about the different departments, if we go down there to 2, where it says honor before, and we get down to the end of that, it says law enforcement agency who regularly interacts with members of the public as part of the law enforcement officer's official duties. So what we're saying, is this wording, was this something we created, or is this something that already exists?
This is the language we received from just talking to law enforcement, because otherwise it would be too broad and it would apply to people sitting at desk jobs and not regularly interacting with the public. So like the entire force, and be way more expensive and useless. So it's just to have the folks that are on the front line engaging. That's where you really want the body cameras.
So I've got to tell you, most of the guys that worked for me were in plainclothes assignments, right? Trying to hide one of these cameras, and when you're working covertly, is rather difficult. So I would think that, but they still met with members of the public. That was their job, all the time. So I think if we're going to do this, there should be a qualifier that they would be Uniform Patrol Division, right? They're in uniform and they're in that division.
Just so this is all, just to be quick, this may head off a couple other questions. So this all has to go back to the policy of the law enforcement agency that we're talking about. So your law enforcement agency had a policy that, covert or undercover officers do not wear cameras, then it would not touch or interfere with that. Senator, is that?
And not having the benefit of being an attorney, sometimes just got to read what it says. But it says, each law enforcement officer employed by the law enforcement agency who regularly interacts with members of the public as part of the law enforcement officer's official duties. That's what it says. That would cover any officer that was employed and working, just not in uniform. We want to make sure that if they were in any type of specialized unit where their identity would have to be protected. I mean, that's the way I read it.
So then here's what to do. We'll add some language that clarifies that it just goes back to the policy of the department, and that way that'll take care of it. We'll just clarifying language. Okay, Senator Sidnor was on this, and then Senator Huff.
Thank you. What I was going to say was, I believe if you were to go back to the original wiretap statute where we began allowing for the use of body cameras, law enforcement officers had to be in uniform because we were not trying to prevent undercover police officers or make them have to wear them. So I think the language is already, I mean, it's not here, but if you were to look to another statute, I think it provides for that. That's not to say that what you're talking about, modifying the language, doesn't help. I mean, if that makes them feel comfortable, that's fine, but I think it's already provided for.
Okay, we can cross-reference the section. We'll do the research and figure it out. But Senator Huff. Okay, got it.
All right, I was just going to say that the big thing with number 2 is that you hit every law enforcement agency, and this is where there's a big difference in the state. So, for example, looking at the folks over on this side, Baltimore City, Baltimore County. Baltimore County doesn't even have municipalities. You are all Baltimore County Police Force, which is a massive, huge police department compared to what we've got in Western Maryland. We don't have a county police force. We've got the sheriff, and then we got municipalities. Carroll County's the same way. Allegheny County's the same way. So if you look at, I'll use Carroll, which I'm part of. They have the Sykesville Police Department, Westminster, Hampstead, Manchester, Tawnytown. By me, I've got the town I live in, Brunswick, it's less than 6,000 people. Thurmont is a little more than 6,000, have their own police force. The whole town budget for Thurmont, I just looked up, all the revenues are $1.5 million. So this is like, Baltimore County doing this is like completely different than going to Thurmont, Maryland and doing it. But I don't think we want to do anything to disincentivize the Thurmont Police Department, Brunswick. It's great because you live in this town, you have a small, localized community policing. It's the model that we should want and strive for. So if we're going to do that, we should really force the state to pick up half the tab. I was going to say for a municipality that's 10,000 or less, because there's just no way that we can mandate this on to these size municipalities and they can pay for it. That might not even be enough, but at least to start, I'd say, and it's not that many, but, and then I'll defer, I don't know if Michael Jackson has anything to add. He's got about 20 municipalities in Prince George's. Their county is obviously a much different setup, but he's got a ton. I don't even know if that would work for them.
Senator Jackson, you want to chime in, or it's up, I mean,
Quickly. Look, so again, Prince George is 27 municipalities, there are about 20 police agencies in the county. Many are small. I think you have the county police and sheriff's office are the largest, and then you have, a couple of agencies for Laurel and Bowie that have 60-plus people, maybe 70-plus people. I think look, I am not opposed to having either GOCAP or the state or somebody in the state ensuring that those agencies can be in queue. There's some previous body camera directives that are out. I don't know if it's from previous years. Maybe it came through 1016, where those agencies could get some help. I think is the year 2025, James? I think it's where agencies had to be fully outfitted. I believe there's some sort of legislation that's out there, or there's been some talk that body cameras had to be in place by 2025.
That may be Senator West.
So I think we should kind of look at need to kind of look at what that language.
Was that yours?
Just yeah, but there's some language out there, and it talks about, I believe, the funding mechanism there, and I'm not sure if it's through the agency previously known as GOCAP or where that help would come for those smaller agencies. I know the larger agencies are systematically outfitting their agencies, but I think somewhere along the line these smaller agencies need to be helped, and maybe 10,000 is the threshold population-wise. I'm not sure, but those agencies need to be helped because if we're working on reforming police, and body cameras is certainly a great tool for the public and the police, then we need to make sure that every agency has an opportunity to get that. So I'd be, certainly, let's look at that.
so it would be, so for a municipality for 10,000 or less, the state would pick up half in perpetuity, or just for the initial startup?
Well, I mean, problem is it's the storage cost, and that's the actual, for them buying the cameras isn't going to be the problem. It's going to be the storage is going to be the problem. So I don't know if I'm trying to look for somebody else who's like a money person and could help us out here, but
equipment is the upfront cost, but then you have the ongoing storage and personnel to review.
yeah, so we might need it to be honest, in perpetuity. Maybe GOCAP will have to basically help them keep store it, or somebody. I don't know.
I mean, I don't know. I mean, I'm sitting here, look, our county decided to do this, and they put the upfront costs, and they have the ongoing costs too. So I'm not sure I see just philosophically why the state's going to just help the little guys
because
and
the
not help
difference is
broader ones.
in my county, the city of Frederick has done it, and they can do it. They are 60+ thousand people. I mean, they have the revenue and the ability. But when you get into a municipality of 5,000 or 6,000, I mean, you're talking $1 million, $2 million total budget a year.
And the other issue with some of these smaller municipalities is that, it's the county and state police that do all the tough stuff we're looking at anyway, and they're mostly doing, parking tickets and pretty low level stuff that isn't like the
But they
main
get that's
objective here.
well,
so
that's not totally accurate. I mean, our guys, I mean, they respond to domestics, they respond to violent stuff. They're there when they do the raids. They don't get just Andy Griffith stuff, unfortunately. I mean, they get drug stuff. They don't.
Senator Jackson and then West.
Thank you, Mr. Chairman. So let me just from a qualifying standpoint, I mean, the agencies, the smaller agencies may not, conduct the major crime investigations, but they do routine everything that occurs. Now, maybe an option is the storage of those go to the county police or the larger agency's jurisdiction. Maybe they couple with them regarding the storage and whatever means they come up with for paying for that. But I think it's vital that each agency and each law enforcement officer, and according to their policies, has these cameras. And then where that storage goes, that's where we work with GOCAP and we work with others to figure that out. And because it's the same thing. So every agency doesn't handle the major criminal investigations. They do the preliminary work. It's like the officer on the street in a major agency hands off his or her report to their criminal investigators. So it's the same thing. So I think it's the route we should probably take there. And I'd be willing to work with the body camera guy, and we can kind of work on that going forward to make sure we get that done. Thank you, Mr. Chairman. And my appropriators.
Thank you, Mr. Chair. It's not as if my bill was miraculous, but it did provide that it only applied to law enforcement agencies that employed more than 20 law enforcement officers, so it intentionally excluded the small municipalities from the scope of the bill. But as I hear discussion about the various counties represented by legislators here, and think of all the other counties which are not represented by legislators on this committee, I'm increasingly coming to the conclusion that as much as I would love to get this thing passed this year, we should consider forming a task force over the course of the summer to get all the stakeholders together. It's going to be a large task force because we'd want a representative of each county, certainly, if not each municipality, and then discuss creatively how we solve this problem. What should the state share of the money be? What should the county share of the money? Should the state be paying money long term for storage in the cloud? If so, then it ought to help Baltimore County, even as it helps this town of Brunswick out in Frederick County. And how exactly would we work this that makes sense for everybody?
So I would agree with Senator West when we talk about the financial concerns. I think Scott Schellenberger said that I think his fee was $2 million, right? When you figured personnel, storage, that type of scenario. So for these smaller, even smaller counties, this is really a significant impact. And I don't know, when we're talking about storage, is this something that the state can help with if they get a big contract, and can Barrick store some of the smaller counties' things? But I definitely think this is probably a situation when it comes to money of this regard that we shouldn't try to solve this right here between us.
Thank you. I just wanted to share with the committee that we had a task force this summer that looked at these issues, and actually, I just received a draft copy of the recommendations that it had. So it was looking at having some sort of a statewide contract where the state helps to negotiate with regards to body camera hardware and software, trying to get rates that would be comparable for everyone, and having some of that data be stored at Do It. Storage, again, was an issue that was addressed. The implementation of it harkens back to 2025, where we're talking about officers working in patrol or public-facing capacity. So these issues were talked about in terms of funding. And just so that everyone's aware, it was me and Senator Reedy, who served on this committee on behalf of the Senate. One of the recommendations was that the state should provide funding that would cover for the implementation and startup costs of body-worn camera programs for police departments, and that the state would create some sort of grant fundings on an ongoing basis that should be available to assist with maintenance and storage costs. We talked about redaction and access, and I'll tell you, just about a month ago, I had an opportunity to look at it was a local state company that is using algorithms and other technology so that those costs of having true man hours or people eyes on it is almost going to likely fall to the wayside, because this software, it actually does the redaction as as the video is being downloaded at the station. So it was and it's able to capture words, so you can do a word search on the video. If you want to blur out people's faces, it will automatically do that. I believe State's Attorney Schellenberger talked about things being on computer screens. This software will automatically redact or blank or put a square over computer screens. I mean, so the technology is getting there where it's not going to be as expensive to have a whole bunch of people doing this. And again, I'm just sharing, just so that you all know, these are some questions that we have been talking about. So I'm not certain when the report itself is going to be officially submitted, but it's in draft form.
Got it. I appreciate it. So what about this then? How about, so I think we all agree that state police should have them. So we can keep state police out and then Senator West, what was your amendment language that you had in your original bill? You had some language that excluded, it set up of a cutoff point. Can you just read that language one more time?
It says, well, on or before October 1, 2023, each law enforcement agency that employs more than 20 law enforcement officers shall require the use of body cameras. The cost of the initial equipment for a body worn camera program shall be split equally between the state and the county or municipality served by the law enforcement agency implementing the program. Ongoing operating costs for the program shall be borne solely by the county or municipality. That was the...
What do you all think about that? Senator Hedelman.
Me? Oh, so as a former appropriator, I don't know how we do this independent from B&T. So, right, I mean, they have to be part and parcel of this conversation, it seems to me. So I just want to put that in there, unless we're, willing to put in an unfunded, a mandate or mandatory appropriation. Philosophically, again, I think the ongoing costs, sure, yeah, the state should help. Should help pay and should help, some of the smaller ones that can't do startup also. I don't have a problem with that.
But under West language, it's the ongoing the costs are going to be borne by the local municipalities and the local jurisdictions, so it's just the initial piece is from the state, right? And the cutoff is 20,000 or less.
20,000 or less? Oh, 20 law enforcement officers.
20 law enforcement officers, sorry, 20 law enforcement officers. Sure, Senator Castley, go ahead.
I like the piece of the proposal where we start pushing the counties out. So you got the big guys are already done. Now you're putting this next group out. We're putting the pressure on there. The tidal wave's coming. You're going to have, what we're going to see is that, I thought Senator Sidnor's information was that was great. I'm glad we could hear, I look forward to seeing the report that you're looking forward to see. But what we're going to start seeing here, I think, is as MML and MACO come into as they're going to see these next row of counties coming in, they're going to start working with the state to, like the point he makes, you do statewide storage. You don't local store at all. Everything goes into the state server, it's stored there. Costs will change. Contracts will be led at the state level. People have the same cameras and buy en masse. I think we ought to be careful of, by codifying some things, we actually retard the progress here instead of pushing it and leave the creative juices. Baltimore County, hats off. They've grabbed the ball and run with it. I think that's awesome. I think the city's running with it. My county's on the verge of running with it. The counties are running with this, and I think to keep I have no problem putting in statutes saying, okay, here's this group, and it's coming. I look at the problems that we have with just like MDEC and getting that out, and how all the problems that caused. Unfortunately, the courts are managing it, so they're not really good at that stuff. But I think you're going to find that with MML and MACO pushing this stuff, they're going to have to, because we're putting 3 out, and we're going to say, next year, we're putting the next 3 out. Next year, the next 3 out. If we just set a schedule, I think we're going to see a whole lot of cooperation on budget cutting, and then leave it up to finance or whoever to say who's going to pay for this. I don't know how we're going to get this allocate. We can tell the state police, but I think aren't they already doing it? I don't know. State police aren't doing this already?
They don't have body cameras. We talked to Colonel Jones the other night. Were you there?
That's ridiculous. I'm sorry. Quite frankly, that's
They don't have it. No, they have.
absurd.
So their cars have it. I mean, Shelley,
Yeah,
you
so
maybe
you
know.
can see the car.
And it's got a 360 kind of.
Yeah,
capability,
but if you got
but-
that, you're just transmitting like the Baltimore County said, you're just transmitting back to the car and it's going up anyway, so.
Yeah.
I'm totally in favor of pushing the body camera stuff. I think that's great. I just don't want to put things in law that are going to end up limiting the abilities here to be creative. I think we've gone for decades without, and we're watching technology move forward quickly. Costs are going to go down. It's a rapidly evolving field, and I think it's a good thing that we're seeing people grab hold of this. They want it. Police agencies want this. Look, in part, it reduces costs. I mean, it reduces litigation costs. It's done. You got there's what the camera showed. Either settle the case or tell the guy to go to heck because it didn't happen. I mean, that's awesome for them. It reduces the times in the courtroom. Get rid of bad cases. Prosecute good cases on the civil side. If the other side shows a film, you fire that officer and you pay him off and go away. There's so many financial advantages to moving forward with this stuff from the government side. I don't see, it's not like we're not pushing them anymore. They've grasped a hold of this and they're running with the ball. So anyway, just think we need to let's not get in the way. That's my only point. Thanks.
Vice Chair Wilson.
I mean, I don't want to get in the way either, but I do think we can spark some of these jurisdictions towards making faster progress. We're doing like some dramatic stuff outside of this bill, but I don't know if you remember the testimony on its behalf. Complaints against officers where body cameras are in play are down 90%. That's an incredible number. So we're dealing with complaints about whether they should or should not be public, and if once a complaint comes in, should or you should not get a trial board. Those are down 90%. No one's having to deal with those even where body cams are present. So if it takes a little extra state money, subject to what Senator Hedelman was saying, coordination with our fellow colleagues on the other committee, why wouldn't we want to push this out? It's one of the easiest, most important thing we can do. It can be bipartisan, multiple jurisdictions. I think this is a dramatic step forward, and I wouldn't want to give up on it just because A, it requires a little dollars, and B, it requires just a little work figuring it out. We can do this. We're big enough to do this.
Senator Jackson.
Thank you. So I just want to kind of, I think I missed a part of it, but also a fellow former appropriator, we had the budgets for GOCAP and for Do It, and I was just recently, until opening day, the co-chair of cyber, where we had Do It, and we're working with them in some different capacities. So I think with the report coming from the committee or the task force that Senator Sidnor served on, was that report due December, or are you aware? So was GOCAP a part of that committee? Was MACO, MML, Do It?
I know Do It was a part of it. I remember College Parks Police Force, the state police. It was a number of police forces that were a part of it. MACO, I believe, did have a representative as well.
Okay, so I think as we all have been assigned a task force and work groups and what have you, I mean, look, I think every agency needs to have these. I think that we should legislate that we're committed to making this happen. We talked about a 20,000 population threshold, maybe 20 officer, 20 officer threshold, and I mean, if that's going to be, is this part of this? Are we amending the amendment on this, or?
Yeah, so I guess, I think you got to.
Can I ask him where he got 20 from?
Where'd you get the money from? Go ahead, yeah. The quantity.
I guess my question is, where did you come up with 20, Chris? Because I was doing Little Brunswick, which is a little over 6,000 people. They got 18 officers, so they're going to be close. They'd be under it, but I'm thinking if they're there, where'd you come up with 20?
To be perfectly honest, there was no magic to it. I wanted to exclude the small municipalities, which were going to come in collectively and say we can't afford it. If you want to do 25, 30, once you get beyond 30, then I think we ought to require them to have body cameras, because you've got a critical mass of people, and you've got multi-shifts and all that kind of stuff. So there was no magic to the number 20.
Departments, I'm trying to figure out what some of them have as far as the numbers of people. Like, I'm looking at Sykesville right now. I don't know. Just curious. I mean, some of these are pretty small municipalities, but I don't know what their officer force is. I'm going to guess a town. It seems about 20 seems just a quick glance, but 20, if we're going to do this, 20 I think is probably a little low. Maybe at least want to go to 25.
Either that or like just pull it to the county level.
Well, the county's a problem, though, because, I mean, look at Allegheny County, the wealth in that county. You get out to the Eastern Shore counties. I mean, that's the other problem. Somebody said, well, we'll put it on the county, which in Prince George's is great. It helps the little municipalities, but Allegheny County and then some of the ones out in the Eastern Shore, they're going to struggle. I mean, Frederick County could probably come in and help do some of this, but I don't know about the rest of Western Maryland, those counties.
Oh, no, I meant excluding the municipalities from the requirement to have them by a date certain. Just have county police.
Just getting out of the...
Yeah. Getting out of the municipal.
Well, the only thing I don't, there's nobody here from the shore, but, I mean, Allegheny's going to struggle on that. There might be some struggles with some of these counties. I don't want to speak for the shore counties, but those might be an issue.
But certainly less than in the municipalities. I mean,
it's better. I mean, look, it would solve
your problem.
It would solve my issues, but I don't want to speak for the shore.
Senator Jackson.
I think that's where we bring in, the GoCaps and the other folks. I think that's where we get the appropriators to say, look, we're trying to do police reform. And if this committee says we want to do it at the county level, if it's only the county sheriff, or it's a county sheriff and county police, I think that makes sense. And then, we work with MACO and MML, or MML with the municipalities. I think we can sort of walk it down.
All right, let's do this. Okay, so we do, obviously, state police. We'll do the next big three, which is Anne Arundel, Howard, Hartford by 2023, just because I know some of them are already on their way. And then the rest of the state at the county level, we push that out to 2025. Does everyone understand that amendment?
Yes.
Okay. So just counties, no municipalities, and the state police.
That's good.
Okay. All right. So just
MML to somehow make a recommendations for a deadline for the municipalities, and can we put it in like uncodified language or something? I don't know, that we request that they come to us with a plan so that we'll implement that, and we just amend this bill next year with municipalities on.
I would suggest is we don't have to do it now, but Chris was onto it, and because he's onto it, he should have to serve on the task force with Sidnor, who likes spending his whole summer talking about body cameras too. I honestly think this is a big. You're going to need almost like a task force. Put MML. You got to have Gaithersburg and Rockville. You guys got big ones that are probably, they have this budgets that are bigger than some of these Western Maryland counties tried together, and then you get the small municipalities. You really ought to get GoCap on there. You really ought to do a task force over the summer to get the municipalities.
we can add that in here. You get the task force to study the.
Yeah, you got the chiefs, sheriffs. I mean.
Yeah. All right, let's do this real quick, just so everyone understands. So, let's just take this one first, and then we'll go to the task force. So it's the state police, and the big three, the next big three, which is Anne Arundel, Howard, Hartford, by July of 2023.
Because we know the other big three are already done. Do we know that?
No, just the top big three are done. So it's
That's what
yeah,
I'm saying,
it's
the top
Baltimore
big three
City,
are done.
Baltimore County, and Montgomery County.
They are done.
Yeah.
Okay.
And then every other county has to have it by 2025. Is everyone okay with that? Yeah. Okay, so that's adopted. Good. All right, so who should be on this task force? To study the implementation of body cameras statewide through every municipality.
Municipalities. So we want MACO. MACO has at least one, maybe two representatives. And we,
MML, right? The municipal league.
I'm sorry, we
Yeah.
MACO and the municipal league, exactly. And that's the way we cover the municipalities. Then,
Sorry, I missed. Just wondering. I was saying that we want the body cameras to be implemented there. We don't want all of them to be on physically on the
No.
task force. Yeah.
no.
Yeah, just to be clear.
So I'm wondering if you don't want to expand the scope of the task force. It's not just the municipalities, but also the counties to look at the implementation of the counties that are coming on in 2025. Because those are smaller counties. Those are not much bigger than your municipalities. You have counties that aren't as big as Rockville. So if we lump all those 2025 people and the municipalities in one task force, because their issues are really kind of same. They're small, and they can all work that together, both MML and MACO.
For that, when you invite the chiefs and sheriffs to be a part of it, because they represent every police agency in the state and every sheriff's office, from Somerset County to, the larger one. So you invite the chiefs and sheriffs, go cap, do it, because you're talking about having state, and I think, maybe the Homeland Security folks, because in our county, Homeland Security is like a mini GoCap, the office I work at. We actually deal with, the distribution of those folks. State has a Homeland Security office. So. I think you have, I don't know, Charles, who else you have?
Someone from the State Office of the Budget who can talk about the cost of this and how the cost will be shared. And someone from the state, whatever the organization does that would handle procurement in the event there's a decision to have a statewide purchase of cloud time.
Just so that everyone is aware, so last year it was House Bill 739 that created the Law Enforcement Body Camera Task Force, and the members, there were 2 members from the Senate, 2 from the House, the Secretary of Information Technology or their designee, as well as 1 representative from MACO, 2 reps from MML, 1 from the Prince George's County Municipal Association, the Maryland Chiefs of Police Association, Maryland Sheriff's Association, Maryland Correctional Administrators Association, the International Association of Campus Law Enforcement Administrators. Those are all, it looks like those are all of the members. But again.
So here's what I'm hearing. So MML, MACO, Chiefs and Sheriffs, GoCap, do it. The Governor's Office of Homeland Security, Office of Budget, and DGS. And you want a member of the House and the Senate? Just the Senate. All right. Yeah, kidding. All right. All right. So what's the scope of their study? To study the implementation and feasibility of body cameras for municipalities?
And the implementation. How about the municipalities and the the implementation in counties for 2025, right? Because you want to help. How do you help get the smaller counties up, and then how do you get this how do you implement this in municipalities?
I would think you would want to, I don't know if we have to specify that in the task force, whether, it'd be funding, implementation, kind of all the issues, to cost sharing, state pickup, local pickup, all those. Do we specify that much in a task force, or just be more generalized? I don't know.
I'm sorry, Senator, I didn't catch.
Their implementation issues, costs of implementation, cost sharing with the state, all kind of.
Yeah, you can add those to a list of things that the task force
Or just stay general.
should
Maybe it's
consider.
better to leave it general and let them figure it out.
I'm sorry, what?
Maybe it's better just leave it general and let them figure out. The task force kind of define their scope.
Well, generally, I mean, just from my own personal experiences of watching task forces work, when something is in the statute, they seem to really try to hone in on that language and try and meet every obligation that they're given. So, yeah, you could add that language in and have them specifically pay attention to those things, or give a broader mandate, and they could use their discretion to figure it out.
Whatever the committee wants to do, I don't care.
So we're adopting this in concept, but then we'll vote. We won't vote on the bill until you see it before you. But go ahead, Jim.
The members of the task force would include the chiefs and sheriffs, GOCAP, or actually the Governor's Office of Crime Prevention, Youth and Victim Services, Department of Information Technology, state budget, Department of General Services, Governor's Office of Homeland Security, Maryland Municipal League, and one representative of the House and one of the Senate. The task force would be responsible for studying and making recommendations on the implementation and feasibility of requiring body camera use in both the counties and municipalities, or police departments serving both the counties and the municipalities. When, I don't believe anybody indicated when they should have their work completed.
Okay. Senator West.
Yes, Jamie, I would say consistent with the provisions of this bill, so that they would take the bill's provisions as a given and then figure how to implement. And there's no reason why they shouldn't report by next year, by the end of the year. By the way, Jamie, if you want some drafting assistance, I just took a look at the House Bill 739 from last year. It would be very helpful to you. It would save you some time this weekend. You could just cobble some of the language.
All right, is everyone okay adopting that just in concept? You'll see it before you when we come back. All right, so here we go. So then we have to cut off. We're running up close to the, we're at our 2-hour mark, so we've got a break. Suggesting we take.
Until Monday?
We've got to do it. We got to do it tonight. So we got a half-an-hour break, and then we'll come back.
What's that? It's like, I'm sorry, I don't want to be, but it's like.
Short break, we keep rolling, or it should be like enough where we can actually get something done. A half an hour to me, it doesn't, but I'll take it if I can get it. If that's all we can get, I'll take it a half an hour.
You might want to.
Do at least a half an hour. So. Do you want?
Time, if we're going to be here, we expect a 2-hour voting. We expect another 2 hours after this.
2 hours?
If that's the case, maybe we should. I will side with Jill over here. Maybe we need a little bit more time so we can go grab something to eat.
Okay, let's do this. How about an hour?
Yes. Fair.
Let's do an hour. We'll come back in an hour. Sorry, Senator
And
Weston,
then,
so
and
sorry.
then it'll still be 2 hours after that?
If it takes that long.
But it won't be more than 2 hours, right?
No, absolutely not.
626 and 627, it's surely going to take 2 hours.
Is that the plan?
No, the plan is just to do LEOBR, and we can, if we look at this, if this is ready, which I'm not sure it is, if not, it's, I mean, we've all agreed in concept to this. The last two bills we've discussed are pretty much worked out. I mean, we're,
So we're gonna vote those.
vote those and then vote LEOBR. So that could take time, the second, so that's,
I've got like 30 amendments.
so.
Yep, that's a lot. I think we should do it Monday.
Okay, so then we're probably gonna do LEOBR.
Monday.
We do it tonight.
Monday night, how about Monday night?
Oh, man.
So 1 hour from now, we'll be right back.